What happens with a trust is that let's say I have a married couple, and I'll deal with a single person after that, but a married couple comes in and they want to avoid the conservatorship as well as the probate. By setting up a trust, we actually have you sign as both a trustor and as a trustee. And what you are is, as a husband and wife, we make you co-trustees. By making you co-trustees, what we say in the document, should either one of us become incapacitated or pass away, that we make the other person the sole trustee. Then we go further and say, hey, if something happens to the survivor, we have a backup trustee and typically a backup to the backup. By going through this process in the document, we now have made it that we don't have to go through the court process. Because all the court wants to know is that while you were healthy, you drafted a document that said you don't need our help. And by going through that trust document and naming ourselves as trustee and naming the survivor as the sole trustee, we now have wiped out the need to have court supervision. So that's why that's very important, and that's how a trust is set up typically. Even with a single person, it's still very important, because if I'm a single person and I become incapacitated, I have the same conservatorship issues. So to avoid that, as a single person, we have that person say, okay, I'm going to set up the trust, and initially I'm going to be both the trustor, the person who creates the document, and I'm also going to be the trustee, the person who runs it. And I'm going to be the beneficiary. So I'm everything. So at the point I become incapacitated or I pass away, I name a person who's going to become my successor trustee and a successor to that successor. By going through that process in writing, I now no longer have to go through the court process of a conservatorship. When I say an estate plan, it's not just the trust. So each person is going to have what we refer to as a pour-over will, a P-O-U-R. It pours into the trust. And the reason that is there is, what if they forget something? Or we've had a lot of times where someone might own a minute mineral or oil interest in Oklahoma or somewhere that they don't even know they own, but we find it. Well, there's only one way to get it in that trust, and that's the will that pours over into the trust. So that's why we have that will is very important. We also draft what is called a durable power of attorney for financial management to allow an agent or a spouse, whoever that spouse is typically the agent, to file tax returns, make gifts, whatever they wish to do financially. We also draft what is called an advance healthcare directive. This is very important as it allows you to name someone to make healthcare decisions for you should you not be capable. And a perfect example of this is what we almost call the advance directive the so-called pulling the plug document, because it allows you to have a DNR or to make sure no one is kept alive and turned into a vegetable if that's not what you want to be. So that is very important. We also do another document called an authorization to release medical records to make sure that we don't have to go through a court process to get those. So doing those documents, and there are typically some other ones we'll do depending on the circumstances, keep us, again, out of the system. That's my goal, is to let everyone run the estate or run the trust or run their family without lawyers and judges telling them what to do.